Thank you for joining us. Digital Assets, a Call to Action is today's STEP Thought Leadership event. Thank you to IQ-EQ for sponsoring the STEP Digital Assets Survey Report and today's webinar. My name is Sharon Hartung. I'm a professional engineer and a committee member of the STEP Digital Assets Special Interest Group. I'm delighted to chair today's event along with my two colleagues, Dave Michaels and Jennifer Ziegel. I'll introduce them formally in a moment. Three quick housekeeping items. First, all delegates have their microphones and videos disabled. Secondly, if you have any question for our panelists, please use the Q&A function at the bottom of your screen. The chat function has been disabled for this webinar. A third reminder, we'll be recording this session and it will be available to watch on demand as of tomorrow. You'll receive an email with a link to the recording. We're here today because STEP and the Microsoft-funded cloud legal project at Queen Mary University of London recently collaborated on a joint research project into estate practitioner views on and experiences with digital assets. The aim of this survey was to understand the extent to which practitioners deal with digital assets, the risks and challenges posed by digital assets to estate planning and administration, and the measures practitioners are taking to assist clients. As we share the results of this newly published STEP survey report, I'm delighted to introduce you to the rest of the panel, beginning with Dave Michaels. Dave is a researcher at Queen Mary University of London, UK. Dave is one of the co-authors of the STEP Digital Asset Survey, along with Professor Christopher Millard. Dave has been a frequent guest at STEP Digital Asset SIG events and has extensively shared his research looking at cloud providers and terms of service. He is the co-author of a chapter on digital assets and clouds in a recently published and updated book called Cloud Computing Law, 2nd edition. Turning to Jen Ziegel. Jen is a partner, attorney, and practice leader of Klein Baird LLC's Trust and Estates Group. Jen has a specialization and industry focus on digital assets. Jen is a frequent speaker and writer on the topic, and she co-founded the Digital Planning Podcast, DPP, which has been ranked in the top 10% of global estate planning podcasts. Jen has also recently co-authored a book on digital assets, estates case study, which will be published in early 2022. Jen is an elected committee member of the STEP Digital Assets Special Interest Group and a co-founder and currently secretary on the board of a national US nonprofit organization called Diversity in Blockchain. Given this event today is to introduce you to the STEP Digital Asset Survey report, we've designed a 4-part agenda. I'll start by setting a few minutes of context. Secondly, I'll invite Dave Michaels to provide us an overview of the survey methodology. Thirdly, then as a panel, which will be the bulk of our time, I'll guide you through three of the 6 major findings. Fourthly, to get some insights from you as delegates on today's webinar, so thank you for joining us, we have 3 polling questions. We'll close, time permitting, with a Q&A from the attending delegates. The goal of today's session is to leave you with a clear picture of the call to action on digital assets. As such, we'll focus on the most pressing results, which clearly present a challenge. But on the positive side, having a clear picture of what the challenge is will help us address the relevant risks. We have the opportunity here to work together as a practitioner community to address this issue for our clients. And there are also opportunities to work early with service providers, and we've already begun to see tech entrepreneurs and solutions emerging in this space. So to kick off, let me set some context. The digital topic is not new. Practitioners and organizations around the world have been dealing with digital assets and the technology equation for many years. Within STEP, STEP launched a digital asset working group in 2013, then formed the STEP Digital Assets Special Interest Group in 2017. And now in 2021, STEP has launched a further strategic focus with the thought leadership team, Digital Assets. Now, why is a global practitioner survey of this type needed right now? The answer poured out in the findings of this survey report. The pandemic has accelerated our clients' digital use. Digital assets have become pervasive, and practitioners have already seen the implication in their practices as the results illustrate. Further, the pandemic has also accelerated the digitization of the estate industry, from electronic will legislation to transforming how clients will want to engage with the front and back offices of not only our organization, but our professions, law, courts, and government. The key findings of this survey tell us that our clients are deeply affected Our practices are impacted, and there's work to do on education, collaboration, and law reform to serve our clients and organizations on this new digital topic. A special thank you to the STEP members who were able to participate in the survey and provide us with these substantive findings. Now, turning to our second agenda item, let me turn to Dave Michaels. Dave, great you can join us, who will spend a few minutes on the survey approach and methodology. Dave, please take us away.
Thanks, Sharon. So I'll start briefly with some background, and then I'll talk you through the survey methodology. So here at the Cloud Legal Project, we look at the legal implications of using cloud services. And we've been looking at issues around digital assets and cloud contract terms since 2015. In 2018, we looked specifically at cloud contracts to see what providers were saying about digital assets and postmortem access. And what we found was that the contracts weren't particularly helpful at all. In fact, most contracts simply didn't address what happened when a customer died. So we knew there was at least a potential legal issue here. And we further saw that issue illustrated by a number of court cases in which heirs had sued cloud providers to obtain access to digital assets stored in the cloud. For example, in the Ajamian case in the US, a bereaved family sued Yahoo to obtain access to a deceased person's Yahoo email account. Similarly, in a case involving Facebook in Germany, the parents of a deceased teenager sued Facebook to obtain access to her Facebook account. And here in the UK, in the case of Rachel Thompson, a widow sought access to the photographs stored in her late husband's iCloud account. But what we didn't know then was whether these were just isolated incidents, or whether the issue of obtaining access to digital assets was widespread in estate planning and estate administration. So when Sharon suggested that we do a survey to ask estate practitioners, we jumped at the chance. So what was our survey methodology? Well, we essentially did three things. First, we started by designing the survey. We wrote a series of questions asking estate practitioners about their experiences dealing with clients' digital assets. And then we submitted those questions for review to senior STEP colleagues and outside experts to make sure the questions were clear, that is, easy to understand and to answer. Then we took our survey to the Queen Mary Research Ethics Committee to obtain ethical approval for our research. The second step was to conduct the survey. So in May 2021, we emailed STEP members and asked them to take part in the survey by filling in an online questionnaire, which they did. By the end of May, we had more than 500 responses, which was great. The third and final step was to analyze those responses and then present our findings. We had two types of data to analyze. First, there's the quantitative data that came in response to our multiple choice questions. Now, this is fairly straightforward to analyze and helps us establish things like what percentage of practitioners have come across digital assets or dealt with a certain type of asset as part of their practice. Second type of data was qualitative data, which we received in response to our open questions. And this was hugely valuable because it gave us direct insights from estate practitioners in their own words. And it also helped us pick up on anything we might have missed when designing the survey. But it is a bit trickier to analyze. See, for some of the questions, we received over 200 written responses covering a wide range of issues. So what we did was we categorized those responses thematically, using codes to identify themes as they emerged from the data. Then we reported on how common each of the themes was. And we also included some quotes from practitioners in our report to illustrate their points of view. And that's how we came up with the survey we're sharing with you today.
Thank you, Dave. It's important to spend a few minutes, as we've done, so thank you for doing that, understanding the survey framework upon which the data is collected, how the results were analyzed, and the findings presented. Now, what about the future? Can we use this survey framework again to track changes over time? Dave?
Yeah, absolutely. I think that would be a great idea, Sharon. We could run the survey again in the future to see how practitioners' views and experiences evolve over time. I mean, that would help us establish things like, are certain digital assets becoming more prevalent? And are some of the problems we're seeing today perhaps being resolved? Maybe because the technology has evolved, or because service providers are offering better solutions, or because of any potential future changes in the law. I think it'd be really interesting to use the survey to track developments in that way.
Yeah, that's going to be great. I look forward to that as well. So turning to our third agenda item and the panel discussion on key findings. So let's get us warmed up. I thought I'd ask Dave and Jen first to tell us what they thought were the most interesting findings in their report based on their perspectives. Now, Jen, what did you find most interesting?
Thank you, Sharon. It's great to be here. I was really surprised that almost 40% of those surveyed are advising their clients to share passwords to their digital assets in order to access them after their death. Sharing passwords for most accounts maintained by service providers is a breach of the terms of service. And in many jurisdictions, it's a violation of both civil and criminal laws. While sharing passwords to computers or devices may be appropriate in certain circumstances, it has to be done with great care and with privacy and cybersecurity considerations in mind. Blanket advice to share passwords can be very, very dangerous and have unintended consequences. Advisors should really proceed with caution.
You know, that's good advice, Jen. Dave, now, what did you find most remarkable?
I mean, if I had to pick one finding, Sharon, I'd go with the finding that only 6% of practitioners found that there was a straightforward process for obtaining access to digital assets in the cloud in their jurisdiction. Only 6%. That's pretty troubling and concerning on a personal level too. When I think of all the photographs that I have stored in the cloud, I'd certainly want there to be a smooth legal process for my family to obtain access to those photographs after I die. What about you, Sharon? What did you think was the most interesting finding?
Yeah, good question. Two things really struck me. First, reading the ad hoc and qualitative data that was provided by the practitioners, we have a deep emotional impact that can happen dealing with digital assets, and a lot of weight on family members during estate administration. And the experiences that we've seen shared by the practitioners really brought this to life. Digital assets affect our grieving, our legacy, and our ability to move forward as we address the death of a loved one. Now, my second observation you would expect is from a technology management perspective. It is clear digital assets can't effectively be addressed in estate administration without pre-planning tools and options during estate planning. The implication for the future direction means that estate planning business processes and solutions will and must become integrated from estate planning to estate administration. And I believe that is the way we'll see consumer expectations and solutions evolve. Now, let's shift gears to our panel discussion. What the three of us did is we selected 3 findings out of the total 6 survey findings to have a more in-depth discussion as a panel. We've selected 1 finding that reflects our client experiences. We've selected 1 finding that reflects the practitioner perspectives, and finally 1 finding that gets at the relationship as an estate industry that we have with service providers and technology companies. Now, starting with the practitioner perspective, those who are dealing directly with clients, we're referring to finding number 1 in the survey report. I'm going to quote from the report. Digital assets have become a common part of modern estate planning and estate administration, with demand for advice expected to increase significantly, end quote. Now, there's 2 interesting data points to highlight for this finding. 1/5 of estate practitioners deal with digital assets on at least a monthly basis, and nearly 60% had dealt with digital assets at some point in their practice. So to summarize, 20% of practitioners are dealing with it monthly, and 60% of practitioners have dealt with digital assets at some point. Now, Jen, can you tell us, is this becoming a regular conversation among estate practitioners, attorneys, and lawyers?
While digital asset planning should be part of regular estate planning discussions now, the results of the study revealed that there's a huge divide amongst practitioners regarding how pervasive digital assets have become in an average individual's life. And I think this has curtailed our growth as practitioners generally in dealing with digital assets in estate planning and estate administrations. The report revealed that 42% of those surveyed had never even addressed the topic of digital assets with their clients. And 60% didn't even know if there was a jurisdictional specific law regarding access to digital assets maintained in the cloud. This is really alarming, as the average person has email accounts and multiple online accounts. And while many clients may not have cryptocurrency or NFTs or operate a business online, the majority are using email or saving documents, videos, and pictures to a cloud. The report highlights that many advisors are either unaware of the mounting need of planning in this area, or really struggle as to how to engage clients in discussions regarding their digital assets, as only a little over half of those surveyed are implementing any procedures to help with pre-planning initiatives for digital assets, such as a questionnaire, an inventory, or another form. There's a lot of work to be done here. And much like planning for traditional assets, the best place to start is having clients complete an inventory of their digital assets and devices. Now, this shouldn't include password information, but this is a great point to begin conversations with clients about their digital assets, as well as helping the advisor identify what digital assets may require additional pre-planning steps. STEP has a fantastic digital asset inventory, and a link to it is included in the survey results to really help with this initiative.
Thanks so much, Jen. That's a great perspective. Now, turning to Dave, how about from an academic point of view? What does this tell us?
Well, for me, Sharon, this finding just underlines the importance of continuing our research in this area, because it's a problem that estate practitioners see in the real world on a fairly regular basis. Yeah. So I think that's one of the takeaways I took from that finding. I guess it also suggests that the handful of reported cases that I mentioned earlier are really just the tip of the iceberg.
Yes.
There's probably a lot more bereaved families out there who would like to obtain access to digital assets, but maybe they don't think to contact a legal advisor, or they don't have the confidence or financial resources to take a cloud provider to court. And I'd like to see a legal framework in place that ensures protection for everyone's digital assets across generations in a manner that's efficient and affordable.
Cool. Thank you so much, Dave. Now, for our second discussion item, we're going to turn directly to clients and the front line of state administration. So for those who are looking at the report, we're looking at finding number 3 in the survey report, and I'll quote from the report. Clients frequently experience difficulties accessing digital assets on death or incapacity of a family member, causing distress and frustration, end quote. 2 interesting data points to highlight. Nearly a quarter of estate practitioners reported that clients have experienced difficulties accessing or transferring digital assets upon death or incapacity. And just under half, Jen pointed this one out as well, were unaware if clients had experienced difficulties. Now, when asked what difficulties clients or families had encountered, respondents mentioned a couple of things: distress, frustration, and other emotional burdens. Now, here's one example shared by a survey participant that really struck me. I'm quoting, "A deceased client's family were very distressed when her WhatsApp account was closed after several months of inactivity. They got a message for the family WhatsApp group that said X had left the group. And as their grief was still very raw, they found this deeply upsetting," end quote. Jen, can you start us off and give us some reflection on this?
So I think some of the disconnect among practitioners hesitant to engage in conversations regarding digital assets with clients may really stem from the fact that many do not view videos and pictures as requiring planning, or do not think that they are worth the time and expense to access during an estate administration. However, many family and friends of a deceased loved one consider pictures and videos the decedent maintained to be irreplaceable or of significant sentimental value. And this was a prominent finding in the study. I'm actually seeing this directly in my own practice. And last week, I was in court on behalf of an estate seeking to gain access to the decedent's cloud account that was maintained with a large service provider in order to obtain the decedent's pictures and videos. Now, this estate was in a position to afford the legal fees and court costs in order to gain access, but many estates are not. And in this case, the will also provided authority for the executor to have access to the digital assets of the decedent. And the service provider still required a court order, which is very common. Many of the big service providers are located in the US, and it may come as a surprise to many outside the US that some of these service providers are requiring US court orders compliant with RUFADA, which stands for the Revised Uniform Fiduciary Access to Digital Assets Act, before allowing access to be granted. And this is even applicable to estates outside of the United States. Now, for those who don't know what RUFADA is, it is model legislation in the United States that presents a hierarchy of fiduciary access to digital assets. And a version of this law has been passed in most states in the United States. Now, in this situation, authority granted in a will to access digital assets certainly helped expedite the court proceedings. They were still required and still will be required in many situations. And this really further highlights the need for better estate planning solutions between service providers and the estate industry, because the amount of our digital assets is only going to continue to grow, even for the most basic user.
Well, thanks so much, Jen. Great discussion with our panel so far. We're going to shift gears for a few minutes. Before discussing the last finding, we have 3 polling questions for our live delegates. Emma is going to give us a hand here with the polling. So Emma, if we can start the polling. Polling question number 1, have you ever dealt directly with a client in assisting them in estate planning and or administration of a digital asset? We're looking for a yes or no answer. Just give that a minute.
Okay, I'm closing the poll now. And Sharon, we have 36% have said yes and 64% have said no.
Interesting results, and very, very relatable to that 64% to the 60% number we've seen in the survey results. That's terrific. So let's shift to polling question number 2. About our personal digital assets, so things you use yourself. If you have a personal Google Gmail account, have you set up Google's inactive account manager? We're looking for yes, I've set it up, or no, I haven't set it up, or no, I don't use Gmail. We know that Google Gmail is a predominant personal email service with 1.5 billion users worldwide. And Google has a personal pre-planning tool called Inactive Account Manager. And this allows you to designate someone in advance to have access to your data upon a period of inactivity, and you choose between 3 and 18 months.
Okay, I'm closing the poll now. So we have 9% have said yes, 64% no, and 27% have said I don't use Gmail.
Okay, that's very consistent with what we've seen in informal surveys. Dave, do you want to comment here?
I mean, I've set it up on my own account, so I'm in that 10%. I guess we could compare it to the survey results. We found that over 80% of estate practitioners had not themselves used a cloud provider's pre-planning tools on their own accounts, and over 40% had not even heard of these tools. So I guess that suggests there's some work to be done here, raising awareness among practitioners as well as clients.
Absolutely, Dave. And certainly starting with ourselves, with our email and social media is a great way just to get comfortable with what is available. So let's shift to the last and third polling question, which is our personal social media. If you have a personal Facebook account, have you set up Facebook's legacy contact? Can be found in settings or by searching help. We're looking for yes, I've set it up, no, I haven't set it up, or no, I don't use Facebook. And Facebook was one of the first major tech giants to come out with these kind of pre-planning tools.
Okay, I've just closed the poll. So we have 16% have said yes, 61% no, and 23% I don't use Facebook.
Okay, Jen, you want to comment on this?
Sure. When you consider these results from Google and Facebook, they're comparable to other informal surveys we've seen globally. Digital Legacy Association surveys have shown that approximately less than 5% of account holders are really using this type of information. And as it stands right now, it does not appear that service providers publish usage data about their pre-planning tools, and nor are they really featuring them on their platforms, which I find really interesting.
Yeah, you think this would be a good thing to advertise, but maybe there's some controversy about it being death. So we have yet to see. So shifting to our last panel discussion on one more survey finding, let us talk about the realities of our new and needed relationships with service providers and technology companies. We'll be referring to finding number 4 in the survey report. Now, quoting from the report, third-party service providers can present practical, procedural, and legal obstacles to both estate planning and administration, end quote. There are 3 interesting data points to highlight here. Dave mentioned this one earlier, but worth repeating, only 6% of estate practitioners considered there was a straightforward process for accessing digital assets stored in the cloud in their jurisdiction. The most cited obstacles to accessing digital assets stored in the cloud included technical restrictions, lack of clarity around property rights, and the lack of estate planning. Now, the 5 providers most mentioned by clients in the survey results regarding digital assets stored in the cloud were Apple, Google, Facebook, Microsoft, Dropbox, all familiar names. And after that, there were some interesting ones: Amazon, Twitter, Coinbase, and Yahoo. Now, Dave, you've studied this topic extensively from a service provider, cloud provider perspective. Why don't you kick off the discussion?
Sure. So as I said earlier, in 2018, we looked at the terms of 35 contracts for popular consumer cloud services. And what we found was that 85% of the contracts did not even address the issue of postmortem access. So they simply didn't have terms that governed what would happen when the customer passed away. And the handful of providers who did address this issue, they all took different approaches. I mean, some of them ruled out postmortem access entirely, while others required either a court order, as Jen was saying, or that the deceased customer had left clear instructions in their will or other similar document. Now, all of this presents a lot of legal uncertainty for cloud customers and their families, and can present challenges to the legal practitioners seeking to help them. And that's clear from the survey results you mentioned, Sharon. It's also something that came through in the practitioner responses. When I was reading them, I was struck by what practitioners were saying about the difficulties they face dealing with uncooperative cloud service providers. Whether that's difficulties, getting in touch with the right team, or cloud providers sending requests for lots of unnecessary information. And taken together, all of this suggests to me that cloud providers are not dealing with this area sufficiently. So why might that be? Well, I mean, one thing we could think of from a provider perspective is that they see access to customer data in part as a security concern. One of their tasks is to protect customer data and make sure that it isn't subject to inappropriate access by unauthorized outsiders. So I can understand they want to be very careful with the data that has been entrusted to their care. At the same time, I can understand that from a commercial perspective, responding to requests for postmortem access may not be a top priority for a cloud provider. And they compete for customers based on features like cost and convenience and cool new things you can do with the service, rather than with how efficiently they deal with postmortem access. But I do think that over time, customers and their legal representatives will come to expect more from cloud providers. And personally, I would argue that cloud providers should do more to act as responsible custodians of our digital assets. Unfortunately, that's not something we're seeing a lot of evidence of in these survey findings. And at least in the UK, we might need new legislation to help address this issue.
Yeah, that's a lot of things to internalize there, Dave. So thank you for that. Of course, one thing that cloud providers are doing, and we've talked about this already, is providing pre-planning tools. And I just want to refresh on the terminology because you won't find that word in the help screen. Pre-planning tools is sort of a general term we're using to talk about the options and choices offered by some online providers for users as account holders. This allows them to express their preferences in the case of incapacity and/or death. And sometimes this can include provisions for others to access account holder data upon certain circumstances. If we want to use an analogous terminology that we see in other kinds of instruments, you can think of it sort of like a beneficiary designation for your online tools. So Jen, you and I have had several conversations about pre-planning tools in terms of whether they meet or not client expectation and wishes. We know there are limitations to terms of service that apply to pre-planning, and there may be a separate set of necessary backup steps that a client as account holder may want to take depending on how they can use the cloud service or the custodian of the digital assets or data. I know you want to comment, so why don't you kick us off here?
I sure do. So thank you. As we're seeing and as was demonstrated in the survey, the estate industry has a lot of work to do with collaborating with service providers in connection with pre-planning options. And as practitioners, we generally know that there are limitations to personal planning generally. You mentioned the online tool as being similar to a beneficiary designation. I really view it as a cousin to a beneficiary designation for traditional assets because it can allow to designate who is the recipient of those assets or the account upon incapacity or death, like Google's Inactive Account Manager for individual Gmail accounts. Whereas enterprise commercial email accounts usually carry monthly fees and may not have these types of online tools, but instead they have options within the account that allow the administrator to designate various users with individual login information and can actually set different levels of access to data, which can be accessed immediately. Consumer-based email accounts really should have more similar options to enterprise email accounts to ensure immediate access to information. For example, in Google's Inactive Account Manager, the inactivity period can be set for a minimum of 3 months to a maximum of 18 months. But if an individual manages their entire life online, from financials to household daily management, getting access to this information is going to be crucial, and it's going to need to be timely. Getting a court order to access this information, if an online tool wasn't utilized, could take the same amount of time as an inactivity period or even longer with added expenses. Also, while many pre-planning tools are similar in some ways to beneficiary designations for traditional assets, they do not have the benefit of well-settled jurisdictional laws that may invalidate these designations, like in certain situations, like in the event of divorce, or if the designation fails. The laws really need to catch up to these different types of planning options to ensure consistency with the transfer of data, and also are accounting for risk mitigation and contingencies. Practitioners and clients generally need to assess if the available pre-planning options meet the needs of their wishes and preferences, or if other types of planning strategies should be implemented as part of estate planning, such as backing up information and data in other vehicles that aren't controlled by service providers.
Thanks so much, Jen. I really appreciate the discussion, Jen and Dave, so far. So why don't we shift to the Q&A portion of today's event? And we do have some Q&A in the window, and I will close the last question on some of the logistics. We have some questions about how the survey can be shared and otherwise, and I'll address those in a minute. But let's get to the good ones. There is a theme here around digital assets as property. So why don't we start with a question along that lines? Are digital assets property? So Dave, maybe you can comment on this from a UK perspective, and then Jen from a US point of view.
Sure. I mean, I guess I'd say it's a big question, Sharon. So lack of clarity around property rights is definitely one of the themes that we saw emerging from the survey. And I think you're right to ask for a UK perspective and a US perspective, because one of the first things I'd say is that the definition of property can differ per jurisdiction. So the answer to the question, are digital assets property, may well depend on which national law you're applying to the digital asset. Second thing I would say, at least under English law, is that it may also depend on what type of digital asset you're dealing with. So over the past few years, we've seen pretty consistent case law emerging both in English courts and across the common law world that holds that cryptocurrencies are a form of property. So they're a form of intangible personal property. But I'm not so sure an English court would say the same about other types of digital assets, like, say, a social media account. So the answer, at least under English law, may depend on whether you're dealing with a Bitcoin or with something like photographs stored in the cloud. The third and final point I'll say on English law is that this is currently an area that's in flux. The Law Commission of England and Wales is looking at the legal status of digital assets, and we've sent them our survey findings, and we've submitted comments on their proposals for reform. And we're hopeful that their recommendations will help solve some of the problems we've been dealing with here today. So that's what I'd say on
Jen?
English law. What do you think, Jen?
So it's fairly easy in the US. Digital assets, all different types of digital assets, from digital photo to cryptocurrency, are treated as property. They're classified as intangible personal property under US law for estate administration, estate planning purposes, as well as for tax purposes.
Cool. Okay, question number 2, when I'm looking at the Q&A, and you both mentioned cryptos, I'm seeing some questions around what estate documents would be required for cryptos and NFTs. Not surprised with NFTs being the latest kid on the blockchain. We're seeing a lot of crypto assets kind of questions. So maybe here's one for you, Jen, to start. Should one identify crypto assets in a will? And do you have any thoughts about estate documents related to that?
So thank you, Sharon. As part of that question, I want to point out that I noticed in the survey results that a lot of practitioners stated that they don't include cryptocurrency or digital assets in wills because in most jurisdictions, wills are subject to public disclosure after somebody passes. And as such, private keys and other usernames should not be listed in a will. While I wholeheartedly agree that private keys and usernames should not be listed in a will, generally, digital assets without these types of identifiers should be included in a will in either a specific bequest clause, such as I leave all of my Bitcoin to Sally, or in more defined general broad personal property or residuary provisions. Now, information associated with accessing the digital assets, like where they're located, the private keys or usernames, again, should not be part of a will, but instead that type of information should be set forth in other documents and roadmaps that are prepared in conjunction with estate planning.
Cool. Okay, thank you, Jen. So I'm just going to go down the list of Q&A. Some of these are meaty and some of these are simple to answer. So let me try to take a bit of the lead on addressing some of the important ones here. So logistically, I have some questions. Let me get to those. Can the survey results be shared with non-STEP members? Absolutely. The link is what you need to share. We prefer you not send the PDF, but the link that you received yesterday to set up for this webinar, or you will receive tomorrow with the replay, certainly share that with STEP and non-STEP members. In fact, we encourage you to use it to have a conversation. Someone also asked about the STEP digital asset inventory that Jen mentioned. The link to STEP's digital asset inventory for digital assets and digital devices is available in the survey report itself and the resource section. Seeing a more technical management question here. I'll read it and then maybe I'll offer a bit of a response on this one. With such a high percentage of respondents recommending password sharing, how does Microsoft's announcement of its continued goal of eliminating passwords through the use of other methods of identification through the MS Authenticator impact estate planning and administration? I'd say from a technical management point of view, greatly. We know that many of these kinds of secondary authentication methods and the use of biometrics is coming into play to address cybersecurity. And it very much makes it a greater challenge for anyone to gain access. Having said that, I think Dave and Jen both made the point that password sharing is generally against the terms of service. So this question raises the conversation that we need to have with service providers and online businesses about what options that we are providing people to effectively do estate planning and estate administration so that we can transfer the assets. Some of the examples that you've heard so far about the pre-planning tools is an effort by service providers to make sure that people's wishes and preferences can be addressed, even though we know that there's some balancing of constraints. Okay, I'm just going to have another quick look through the questions here. One question, can cloud providers offer beneficiary designation for their accounts? We've had quite a bit of discussion on that with both Jen, Dave, and myself. Certainly, we use and we liken these pre-planning tools as a form of beneficiary designations, although we know there are legal basis for beneficiary designation in specific instruments. It's certainly an option in the future. But as Jen also pointed out, there's some constraints. So when we think of Google's inactive account manager and the role of the fiduciary executor needing access to information right away, waiting 3 to 18 months. And then the twofold challenge of the fact that you may not even select your fiduciary in that role. So from that perspective, we also have to look at the needs of estate administration from an information perspective. How should we be coaching our clients in terms of leaving the necessary information that will be readily accessible for them to do their jobs? Just one last check on the questions here. I think we've done a fair job of tackling most of them, which is great. So with that, we're coming to the close of our time today. And before I do that, I want to just see if Dave or Jen have any final comments they want to make, as we've had a great conversation today.
Thanks, Sharon. Well, if I may, I did see another question in the chat box.
Sure.
Sorry, I don't know if we have time. I'll be really quick.
Yeah, go ahead.
There was a question which asked, which jurisdiction has the most forward-thinking legislation on digital assets and why, and what characteristics could others take from it? And so I think actually that what we're seeing in the US and Canada with UFADA and RUFADA, what Jen mentioned, the revised uniform, I'm stuck in this one, Fiduciary Access to Digital Assets Act.
Right.
I think actually that's probably at the forefront of legislative developments in this area. We don't have anything quite like that in the UK, and there's nothing like that at the European level. And I know some European member states have chosen to address this issue as part of their data protection law. So you might find relevant provisions in like French data protection law. But I think the example of having specific legislation for this issue of postmortem access, looking to the US and Canada as an example, would be probably where I see the most forward-thinking legislation. What characteristics others could take from it? I think dealing with it as a specific access issue for fiduciaries is a really good approach. There's a question around, so I think everybody, well, all right, let me rephrase that. Most people would agree that where the deceased customer has left specific preferences, that we should respect those wherever possible. The question is what to do when the customer hasn't left instructions, right? And under some versions of RUFADA as implemented, you then turn back to the terms of service, which we saw when we looked at cloud contracts, and those aren't necessarily particularly helpful. So I'm not sure if I were advising, what to do with English law in this area, I'm not sure I would cede to terms of service of cloud providers necessarily. But yeah, those are my few thoughts on that particular question.
Great. Jen, any closing comments?
Absolutely. So I echo Dave's sentiments that the US is very forward thinking in this area. And I think RUFADA, which is a mouthful to say, that's why I always just refer to it as RUFADA, has really paved the way to set examples of what legislators around the world can do. And I do want to point out that under RUFADA, there's actually a hierarchy of fiduciary access. So if a person has utilized an online tool, that's going to take precedence over provisions in estate planning documents authorizing access to the same digital asset. And then again, if there is no online tool or digital asset access provision in a will, then Dave's absolutely right. The terms of service control. And as we're seeing that they're really, really lacking. Going back to the point about inactive account managers and online tools, I think one of the issues that I'm seeing a lot in practice is on a death certificate, it doesn't have the user's email account. So correlating and corroborating that the username and email associated with an account is actually the decedent's username can be very difficult to have, definitive evidence for court proceedings. So one technique that I'd like to share with you that I've imported into my practice is actually having clients separate from a digital asset inventory, actually writing out their usernames and email address and then signing and dating it as a statement that could ever, if we needed it, could be used as definitive evidence that the email account is their account for helping with court proceedings and gaining access to this type of information. But we have a long road to hoe, and this is just the beginning of these types of conversations that are taking a deep dive as to where we need to grow as practitioners and how we can partner with the service providers to really make pre-planning for these types of tools seamless and account for cybersecurity, privacy, and just access to digital assets for regular management in incapacity or deceased estates.
No, that's a good one. And I've always said you may have one nickname, but you might have hundreds of usernames. And if we're moving away from email, how do we know what an individual has, which is one of the biggest planning tenant challenges of digital assets, the fact that they're virtual in nature and they need to be identifiable from an account identifying information perspective in order for someone to address them. And as we've both got into that conversation with Dave and Jen, a lot more questions have popped into the chat window, and we do have a little more time if we want to try a few more questions. There's a couple general questions about the roles and responsibilities of estate planners and their obligations as it relates to digital assets, particularly if they become challenging to address during estate administration. So I can't speak on behalf of every profession, but maybe I'll start off with that. And if Dave and Jen want to comment, I talk a lot about, from a technology and management point of view, the data will integrate us, that what tools and solutions we have in estate planning will need to merge and morph and integrate into estate administration for this to work in the fluidity that we will need it to work. And with that integration becomes and drives the responsibility of the professions to understand that the advice they're giving during planning will affect estate administration on digital assets particularly. I think there will be a need for all of us to become more technically aware to the degree that we can advise clients to go and get professional advice, perhaps from technical advisors who specialize in specific areas to get advice on their specific digital assets. But as practitioners overall, Dave and Jen, did you want to comment about responsibilities in terms of making sure that they provide advice that is reasonable and applicable in estate administration, although things will continue to change and evolve?
Sure, I can comment on this. In the US, there are ethical codes of conduct for attorneys, and in these ethical codes of conduct, it requires attorneys to stay abreast of technological developments that they might need to be aware of to aid and administer estates, and also in order to properly advise clients. So in the US, we're starting to see that if digital assets are not becoming part of discussion points, it could potentially open up the advisor later down the line to potential issues of malpractice if this category was never discussed. And I have seen in my own practice a lot of clients themselves hesitant to engage in digital asset planning or really go down the rabbit hole of those types of deeper discussions. And so what I've recently begun to implement is for clients that really don't want to take part of those discussions, I have them sign an acknowledgement statement that they were told about digital assets, told about all of the legalities and issues that could become applicable if proper pre-planning measures were not taken, and that they're choosing not to include this in estate planning. And I think right now that's probably the best option we have if we're dealing with digital assets and clients don't want to engage in conversations. On the opposite end, with estate administrations, it's a discussion point I have with clients or the executors of estates early on in the relationship to determine how far they want to go and how much time and expense they want to utilize in terms of our teams for finding digital assets. And of course, in more complicated situations, just like you would go to a professional appraiser for valuations of fine art, you need to go to technologists and others. Also, there are valuation specialists for particularly with digital assets. You need to have these types of people in your arsenal that you can call upon when needed, when these situations come up.
Thank you, Jen. That's great. I see you have a couple of questions here about the definition of a digital asset. And instead of giving a country-specific example, what I will generally say is I'd have you refer to your Fiduciary Access to Digital Assets Act uniform model language if that exists in your jurisdiction. Certainly, we have one in Canada. We have RFADA in the US. And if you want a definition of a digital assets, sometimes you might even want to consider not only the formal definition, which is as simple as an electronic record, or what property rights that are drawn from it, which will be defined by your jurisdictional language, but you can also provide relatable definitions to clients. I often say digital assets are our memory, our money, and our records just in digital form. The STEP digital asset inventory provides some categories of examples, things that are digital accounts that provide us access to an underlying asset versus a pure digital asset like cryptos. So there's a number of sources that you can use to come up with a definition, starting with your own jurisdictional laws and then the digital asset inventory. I see another specific question here, which is interesting. What special considerations are there for social media accounts that generate significant amounts of income? I'd have to say, from a technical management perspective, maybe I'll kick that one off. The first thing that is important for clients to do when they have a significant digital asset is take an inventory of that asset. Often we'll find that folks will have something they think of as significance, perhaps their website or even social media, when in fact there are several accounts associated with it. And probably the special consideration I'd say for social media accounts is making sure that the client is using it for the purposes it was intended. I often see small business owners, for example, setting up personal social media accounts and then turning them into their business versus using enterprise, as Jen pointed out, enterprise business licenses, which afford a lot more options as it relates to business continuity, right? So if you use a business license for a social media account, there's a lot more facilities through administrator access to allow others authorized access while they're living. And then you can wrapper your legal and business succession planning documents around who will have access after incapacity or death. So there's some planning elements there that are relatable from an estate planning perspective. So I'll give Jen and Dave one last opportunity to make a comment before we close, because we are really coming to the end of our time, and I really appreciate all the questions that our delegates have provided today. So Dave, Jen, any last comments?
I'll just say thank you, Sharon. Thanks for hosting this event. Thanks for suggesting the survey. Thanks for all your help throughout writing the report. You're a real driving force in this area. And yeah, it's been great for our research, and hopefully some good will come of it for families out there as well.
Thank you, Dave. That's fantastic.
Absolutely. Thank you very much, Sharon and Dave. It was a pleasure to be here today. And thank you, STEP, for being so progressive and forward-thinking to really bring this issue and highlight all the problems that we face and how we can now work together as a community to really create better solutions for these problems. Great.
So I encourage all of our delegates, both live and through the replay, to read and share the STEP Digital Asset Survey Report. It includes facts, figures, and anecdotes, and they offer a basis of discussion and a real opportunity to dialogue with your clients, your colleagues, your professions, and your respective organizations. We know accessing digital assets after a loved one's death can pose a challenge, as digital assets become more prevalent and our lives become increasingly entwined with digital technologies. The need for effective estate planning processes and solutions becomes ever more critical. These solutions, we know, requires a joint response. Bodies such as STEP and its members can engage with governments and service providers globally in order to produce best practices that will help families plan for their futures with certainty and clarity. I want to thank Dave and Jen for joining me today. Always great to talk to you both about this subject. Now, for those delegates who joined us live today, thank you for tuning in and being part of our Q&A session and our polling. Really appreciate that. Right after the live session in a few minutes, an online feedback form will appear on your screens. We'd very much appreciate you taking the time to share your feedback, as it will help us plan future STEP events. After today's live session, you'll also receive a link to the replay. The next webinar in the Thought Leadership series will take place on 19th of October and cover mental capacity. I encourage you as delegates to sign up for any one of STEP's special interest groups if you haven't done so already. It's currently no charge and you do not need to be a STEP member, and you're welcome. And we encourage you to invite your colleagues in the industry or at your firms to join as well. I certainly hope you'll join the STEP Digital Asset Special Interest Group that Jen and Dave and I are part of as we collaborate on this digital topic. I hope you'll join us in again on November 30th for the Digital Asset Spotlight event. And a final big thank you to IQ-EQ for sponsoring the survey and this webinar. We're signing off. Thank you and goodbye.